They can choose. I've told them it's my legal opinion that they can. I suggested that we do a study to see that the value of what was done, because in the end, where there wasn't really a contract, your side is basically, I've done this work, I need to be paid for the value of it. Well, that's not necessarily what you invoice us. We should do our own study, because we're the people that's paying for it, the government in Morgan County. We need to say, look, this is how much this is worth. Since there's not a contract, we got to go by how much it's worth. Now, I have no doubt that it's close, or you might even be giving us a deal on it, okay? I'm just saying that I've told them we need to do this study. Let's see how much it's worth. If it's worth it, pay. I withhold my personal opinion on it. I represent Morgan County, but this is an option open to the fiscal court.
It's been done getting, I guess, close to 10 months or something like this. And we was going to, I think, back in the other court meeting, we was supposed to go around and look and make sure all of it was there, what we said. So it comes back down. So there was 3 or 4 months wasted there as to what you said. Who you going to send around? You got your road foreman there, and he's been to every one of them. McClure, I thought of his name that time, didn't I?
We're close.
I don't. I'm an attorney. I'm a prosecutor. I don't do these studies. The fiscal court. We were supposed to kind of figure out how much it's worth. I don't know how much a bridge is worth.
I mean, again, we're getting into another question. Only question that was in here a while ago before you ever walked in was, Judge, break it. That's the only question before you ever walked in.
I gave my preliminary answer, but I do want to withhold. Let me research that, and I can get you all memo today.
Well, they're trying to find out right now, the AOC's, to give them some information about whether I can vote twice or not in this situation.
Well,
now, is that acceptable?
Keiko too. I'm going to issue my own.
Yeah.
But I kind of want to withhold until I, can speak intelligently about the situation.
Miles, what is the difference between Judge Conley agreeing with whatever that organization was with the tent without fiscal court approval? And
The tent.
With Lundergan? And what's the difference?
This is what I'm trying to dance around with this whole thing. It's public knowledge. It's public record, okay? There was a company that sued Morgan County for a whole bunch of money. They threatened to sue for a whole lot more, but they ended up threatening to sue suing for actually around $1 million. There wasn't really a contract. Two people shook hands in a room, okay? So the details were left for later. Well, when contracts tend to break down and people have misunderstandings about what goes on, not having a contract is kind of fatal. It makes things go real bad. That's at the point that it's not like what they had done just goes away. I mean, they had done something. There had to be studies to figure out, hey, how much was done. We got to figure it out, not just what you're telling us. Okay, that took a long time. I think the judge had like 3 secretaries at one time working for 2 months. That's all they did was go through invoices, match them up, call different companies. How much you charge for this? How much would you come to West Liberty to do this? It's a little bit more complicated than, I can't go out and look at this bridge. Oh, that's a $140,000 bridge. I'm a lawyer. I've got to have somebody that knows what they're doing to sign a piece of paper and hand it to the court. Okay, that tells me something, not something that somebody that really don't know what they're talking about. That case proceeded on what's called quantum merit. I hate to be the professor in the room, but it's a theory that if you do something for somebody and it has value, then you should probably get paid for it. Okay, so that's kind of where I'm leaving you at. The fiscal court, the magistrates and the judge they can. It's just that they haven't decided to. Now, I don't know why they haven't decided. You could talk to them individually or whatever, but that's not up to me. I've just got to defend our right. As I said, I have suggested we get somebody in there that knows what they're doing and give me a report. We can talk to the fiscal court and they can vote on it again. I can't, I'm not a voting member of the fiscal court. Whether you get paid, I have no say-so in that. I just say you can get paid.
Well, okay, what do can the fiscal court do the word vote for me to go back and pull my steel and stuff out? I'll take my loss labor. But I want the advice.
I represent Morgan County. I would say if somebody that's trying to destroy a road would be arrested on the spot.
But we ain't paid for what we've done.
That is a contract issue. I understand, and I understand your frustration.
Okay.
I do.
I spoke with Bill Pauley at DLG, he's legal representation there, and I also spoke with Rich Ornstein. They can give me a legal opinion, or a personal opinion, a legal opinion, what they feel as attorneys. They both said it has to be paid out. They said if it goes to court, there's no way that they did their work under the impression that we were following procedures. So therefore, if we go to court, we're going to pay it out. That's what they told me. As far as a second vote to break the tie,
can I interject? At this time,
We'll let her finish what she's.
well, that's kind of the problem. When I'm answering a question, I was answering in general terms. We're right now saying that we're admitting liability for it. Our own court is saying that we're just admitting liability for it. That's what I wanted to talk to you all in closed session. When somebody's threatening to sue you, and you blurt out, something that they can use against you, then that is not good. A jury can hear that, a judge can hear that, and whatever. So the following interpretation by the treasurer of what some other attorneys said, if said at all, needs to be said in closed session so that we don't create liabilities for ourselves.
Could we not adjourn and have a special call meeting, say Monday, and give you a chance to look at the legality part of this, come back and, without you looking
I've
at the
agreed.
legality part, again, you're just assuming like they did, a personal opinion instead of a legal opinion.
Before Lindsay stopped, you could kind of see that I was saying some of the same things that without saying the liability. I would love to talk to the court in closed session because, as I was telling him, we know you've done work. Okay, the court can vote on it. I was just trying to not admit liability in front of our potential
well, if it's
opponent.
under litigation, can we go into closed session? We have it on the.
Yes, that is what
Well, why don't
that
we do that
I've
instead
said.
of
That I've said.
All right, do I hear a motion that we go into closed session? All right, second lady. All in favor? Aye. All right. I hear a motion, we go back in open session? Motion. Second. All in favor? Aye. All right, do we need to go with a third, vote? Randy?
A third vote if you want.
All right.
Anthony's gonna make that motion
I'll
again.
make that motion again.
And second. All in favor? Aye.
Do a roll call. Denzel Potter?
No.
John Brown?
No.
Stanley Rigsby?
Yes.
Brandon Evans?
Yes.
Anthony Likens?
Yes.
Stanley Franklin?
Yes.
Motion carried, I guess.
Okay.
Motion to adjourn.
Anthony's making that motion.
Yeah.
Did we pay the
John
bill?
Brown second.
We didn't pay the bill before we went into closed session.
Paid 1 hour ago.
Yeah, we paid the bill. All right.
Made the motion to adjourn.
All right.